welcome to all of you. It's not a difficult segue to go from bail reform to the question of prosecutors and the role that prosecutors play in the system. We've called this sort of a generic term, prosecutor misconduct, but mainly because we're looking at some very good studies that the Quattrone Center has done and the larger issue of the role of prosecutors in the reform of the system. As I don't have to say or tell you that some prosecutors are under huge pressure right now because people have felt, opponents have felt they've gone too far, again quoting the crime rise as a result. To take us through it, I'm pleased to have John Hollway as our moderator. John is Associate Dean and Executive Director of the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School. The Quattrone is a national research and policy hub created to catalyze long-term structural improvements to the U.S. criminal justice system. And before I start off, I want to say how grateful we are for the Quattrone Center, to the Quattrone Center, not only for its partnership with us on this panel, but for its support of our Special Investigative Reporting Fellowship Program. This year, we have 4 distinguished journalists who are participating as Quattrone Fellows. I'll just list their names very quickly. Kate Heather of the Pantograph in Indiana, Tristram Corton, who is an independent magazine journalist and former editor of the Florida Center for Investigative Reporting. Jerry Mitchell, who's a Pulitzer Prize finalist and founder of the Mississippi Center for Investigative Reporting and a longtime crusading editor in Mississippi. And finally, Chris Palmer, who covers law enforcement at the Philadelphia Inquirer and is currently spearheading several projects examining the city's gun violence. So I'm going to toss the microphone over to John, who can explain a little bit of how the session is going to go. And we'll talk particularly about the latest report that the Quattrone has done on Pennsylvania. So John, over to you.
Thanks, Steve. It's a real honor to be here. We've partnered, as you know, Steve, with you and John Jay and the Harry Frank Guggenheim Foundation for many years on this symposium, which I think is a rare opportunity to elevate the discourse about criminal justice reform around the country. The Quattrone Center has been focused for quite a while on the area of prosecutorial misconduct. I think there are few things that shock the conscience or undermine the legitimacy of the criminal justice system more than the idea that ministers of justice might in some way manipulate the system in order to secure a conviction or to put their thumbs on the scales of justice. And anyone who takes a quick spin through the National Registry of Exoneration or the Innocence Project or other websites that catalog wrongful convictions or exonerations can see that there have been egregious examples of that conduct, and those stories are increasingly finding their way into the mainstream media, whether it's through podcasts or streaming services or blogs, etc. But we tried to ask a question at the Quattrone Center that I think has really only been asked once before, really 2 questions. One, when we use the words prosecutorial misconduct, are we all talking about the same thing? Do we really know what prosecutorial misconduct is while we're busy getting, all spun up about the challenge? And 2, do we really even know how much misconduct there is and how it's being handled by the criminal justice system so that we have a starting point for improvement in the system? In other words, we can only make misconduct better if we can accurately identify it, agree on what it is, understand the extent of it, and figure out how to move forward from there. And so the first study that we saw that did this was from the Veritas Institute in California. It was called Preventable Error, a report on prosecutorial misconduct in California in 1997 to 2009. And the second study is the one that Steve referenced that my colleague Ross Miller, who's here with us, and a lot of other folks put together for the Quattrone Center, called Hidden Hazards, Prosecutorial Misconduct Claims in Pennsylvania from 2000 to 2016. I'm going to let Ross go into the details of it, but what we're going to talk about today is those 2 questions, right? When we use the words misconduct, what do we mean? And how much misconduct is there really? What do we know? What don't we know? And how is it being handled by the criminal justice system? And so we've got a star-studded panel to help us talk through those things and talk about efforts that are already underway to try to reduce instances of prosecutorial misconduct and to improve the quality of prosecutors, really not just to get rid of instances of misconduct, but to promote existing good prosecutors, good practices in prosecution, because one of the challenges we have when we don't really know how much there is that the good prosecutors end up getting tainted by the quality flaws of those who do cross the line from time to time. So I'm going to briefly introduce our panelists. Then we're going to turn it over to Ross to give a quick, like 5-minute snapshot of the report. And then we're going to have what I'm sure is a really fascinating conversation. As you'll see once I introduce the panelists, they'll have a lot to say. So I'm going to introduce them in alphabetical order, starting with Mark Fondacaro, who is a professor of psychology and director of the doctoral training program in psychology and law at John Jay. He's a co-author of Juveniles at Risk, a plea for preventative justice, and is the author of numerous articles in law reviews and behavioral science journals on issues of procedural justice, due process, family conflict resolution, and juvenile and criminal justice reform. He's currently working in his social justice laboratory on a series of empirical studies to identify defendant and situational factors that might bias judgments of criminal responsibility. Kim Foxx, who is currently the Cook County State's Attorney's, the State's Attorney in the Cook County State's Attorney's Office, one of the largest prosecutor's offices in the country, where she has served since December of 2016. And I know your highest accolade, Kim, is being on the advisory board of the Quattrone Center, so I'll just get that out of the way because I know you would rush to say it otherwise. During her tenure, State's Attorney Foxx has revamped her office's conviction integrity unit, which has resulted in overturning over 80 convictions in over 80 cases, including the first ever mass incarceration in Cook County. She's been a leader in bond reform, reviewing bond decisions in cases where people are detained because they're unable to pay bonds of $1,000 or less, and has taken the lead on prioritizing resources away from low-level offenses to focus on violent crime. Perhaps most importantly for the conversation we'll be having today, Kim is the first and only prosecutor in the country who has made felony case-level data available to the public. The Cook County State's Attorney's Office Open Data Portal provides unprecedented access and transparency into the work of a prosecutor's office, and I think that's going to be a really important focus of the conversation we have today. Miriam Krinsky is the founder and executive director of Fair and Just Prosecution, an organization that brings together elected local prosecutors as part of a network of leaders that promotes a justice system grounded in fairness, equity, compassion, and fiscal responsibility. She served for 15 years as a federal prosecutor and has a litany of roles and awards in her time there, including the Attorney General's highest national award for appellate work. And finally, last but not least, Ross Miller, the Assistant Director of the Quattrone Center for the Fair Administration of Justice, and somebody whose work I get to claim as our own and ride on its coattails. Ross has been an experienced criminal defense and civil rights attorney in federal and state courts. And prior to entering private practice, he was an assistant defender with the Defender Association of Philadelphia, serving as a trial attorney in the Major Trials Unit. Most importantly for this conversation, though, Ross is the primary architect of the report we'll be talking about. And so to set the stage, I'm going to turn it over, Ross, to you, and we'll go from there.
Thank you, John, and welcome, everyone. So glad to have the opportunity to present some of our research to you. As John mentioned, the report that we recently published, and John, if you could just give me the share option here.
I think that'll be Christopher Graham there, who has the ability to do that. So both my pay grade, as it turns out.
Okay.
You're all set. Thanks.
Okay, thank you. As John mentioned, our report, Hidden Hazards, is focused on examining prosecutorial misconduct claims in Pennsylvania in the years 2000 to 2016. So what that means, and the method that we chose, as John mentioned, there was one other version of this approach of looking at judicial opinions to understand prosecutorial misconduct, which was done out in California. And so we started from there and then ultimately developed a couple of other analyses that we thought made it a little bit more clear what we were discovering and sort of the limits of what we were trying to do. So the primary method was to gather all of the published judicial opinions in which the term prosecutorial misconduct occurred. As John mentioned, we didn't want to go into this with a preconceived notion of we're going to say what misconduct is and then look for it. We just wanted to find out how that term was being used and what kinds of conduct and characterizations were associated with those claims. When we did that, we came up initially with a little over 5,500 opinions. Those came from two primary sources. As you see here, a little over 3,000 came from Westlaw, which includes any published documents on Westlaw with a search limited to the state and federal courts for Pennsylvania. We also reached out to the Superior Court of Pennsylvania, which is an intermediate appellate court. They have a number of opinions and memorandum opinions that are not published and are not available by way of an electronic database. And they worked with us to conduct the same search in their database and provided us with a tranche of an additional 2,100 cases. So then what we had was a big pile of opinions in which prosecutorial misconduct theoretically appeared. We then, with teams of research associates and number of staff folks at the Quattrone Center, went through those opinions to code them and determine a number of things: what the conduct was that was alleged, whether or not the court addressed that conduct in any substantive way, and most importantly, whether or not the court found that misconduct or found that misconduct occurred. And it's very important, and this is explained in great detail in the report, when we say misconduct found, that means that the language in the opinion either assumes or specifically finds that the conduct occurred, and so the fact that it happened is not in question, and that conduct was illegal or inappropriate or otherwise impermissible within the court setting. So with that in mind, as we looked at the initial group of cases, you see here we kind of had a nice distribution between state cases and federal cases. We got down to about 4,600 opinions that contained cognizable prosecutorial misconduct claims. From those, about 3,400, the courts actually addressed those claims. And in 145 of those cases, by the definition that I just gave, the court found that misconduct had occurred. Now, that one of the first things we wanted to do is just describe that and give some idea of the distribution. As you see here on this chart, and again, there's a lot more detail in the report itself, there were two big categories that were responsible for a great deal and over half of the total number of claims. And that was exculpatory evidence being withheld or not provided by a prosecutor, and improper closing. Something that's pretty interesting that we talk more about in the report is the third largest category was other. As one can probably imagine, there were a number of opinions, a very high number, here's 958 claims, that were too difficult, too nuanced, and too sort of fact specific to stick into a particular bucket. And then you can see here the rest of the way these kind of went down. Other improper remarks, that's referring to things made at trial, is another pretty large example. Improper examination, again, something that happens in trial, and then gathering and presenting false evidence. And then as you see, it goes down into much smaller numbers from there. This blue bar represents the number of claims, so not necessarily opinions, that's the number of claims that are raised. The orange bar is the number of those that were addressed by the court, and then the smaller bars on the far left should give you an idea of how many of those claims were found. So that's the overall distribution. This was relatively consistent with what we had seen from California in their prior report. So when we got that information in, we were very happy to be able to report this sort of distribution of claims within those opinions. But as John mentioned, we accepted at the outset that this method we were choosing was one that was inherently limited, because our data source was only published information from the court in which this language occurred. It certainly wasn't getting at the larger scope of what happens in the criminal justice system. So a lot of the report is spent explaining why, although we may have identified a lower bound for the occurrence of conduct that rises to the level of misconduct, there are reasons to reasonably believe that the true number of incidents, the true number of events is significantly higher than what we were able to find in this data source. And there are a couple of approaches to that. One, which will not come as a surprise to anyone who has any practice experience in the system. Part of the initial issue that we're facing is when we're looking at opinions that are coming from a court that's dealing with a specific issue, the vast majority of those opinions are being generated by something related to the trial process. When you think about criminal justice as a whole, trials represent nationally 2% or less of all the criminal cases that find their way into the system. In Pennsylvania, and as you see here, we excluded Philadelphia because Philadelphia has a unique two-tiered jurisdictional court that makes it a little bit different than typical. But looking at the rest of Pennsylvania, which is more typical with what you see across the country, you see out here we had over 1 million criminal cases that were processed during the 17-year period. And out of those, 2% went to trial, 70% guilty plea, 21 diverted, and 6% were withdrawn. So that's the first sort of important way to understand how what we discovered is truly a lower bound, and that the true number could be significantly higher. There's a lot of invisible, and I say that with the idea that there's no public records for many of the prosecutorial actions that took place in those cases. So it's very difficult to understand and know more about what happened in those other processes. One of the other things we took into consideration looking at opinions was the availability of the opinions themselves. Over that 17-year period, there were over 180,000 trials, but there were only 77,000 appeals, 57,000 with an opinion, 54 published, unpublished, and then only 2,700 that led to published opinions, which, as you see here in the numbers, that means that there's only one published opinion for every 66 trials that had occurred. So even with the narrow lens that trials gives us in that 2%, when you're relying on published opinions, it gets even narrower what you were actually able to see. So from there, we made a set of 10 policy recommendations, and there will be a lot more time to discuss this over the course of the meeting today. And this is what I think the other folks on the panel who are actually out there doing these, working to resolve these issues, will have a lot more to comment. But you can look at the report. We sort of divide them into two main categories. One is preventative, the other is accountability. And as you see here, these are things that will probably not be too surprising to a lot of folks that have been working in the reform space. But this is all motivated, and in the report, we explain how each one of these links back to one of those things we were able to observe in the data, especially about where these issues that may be concerning in terms of being errors in the criminal justice system may be occurring, and how available information is so limited for all those reasons that I explained and are explained in the report. So that kind of is a nutshell of what the report sought to accomplish, with the heavy caveat, the report probably spends as much or more time explaining what we can't say than what we can. But we think being able to do this description and put it in context of the larger system, we certainly hope that that's helpful to understand what these issues are and to come up with creative solutions to address them.
Thanks, Ross. And for everybody who is listening, what this group decided we were going to try to do was have this be as conversational as possible. So I'm going to, ask some questions to get us rolling, but we don't really know where it's going to go. And I hope that those of you who are listening will be putting questions into the Q&A or into the chat. I am watching those, and we will respond to those as we go, and hope to get as many of those answered as possible. But let me start by kind of commenting on what for me were kind of the practical takeaways of the data that Ross showed, right? The first thing that I took away from it was how hard it was to collect this information. We had to gather all these individual cases. As Ross said, I think 40% of the total data set was actually unpublished. So if the Superior Court had decided not to help us, we wouldn't have had access to that. We had to go through them one at a time, and we're not aware of any systematic way of gathering data on prosecutorial misconduct, right? And Ross laid out a lot of different areas, right? One of the things that I think often happens is when we hear the phrase prosecutorial misconduct, we all gravitate to withholding information. But as Ross showed, there are a lot of different types of things that courts classify as prosecutorial misconduct. Improper closing argument is one of them, but most of them are happening in open court, right? So there's a big difference between a prosecutor saying something and there being an objection and it being handled in open court. That's far less deceptive than where we all go in our minds, which is, I've got this smoking gun and I'm just going to put it in my pocket or in my desk drawer and nobody ever needs to see it, right? So one is understanding that, but two is how difficult it is to gather the information. And three is, even after you do all the work that Ross and his team did, how big the gap is of information we don't know. And so, Kim, let me ask you first, you've got this portal. You're not embarrassed by data, right? Let's use the data and set a baseline. And one of the things that I would say about this report is if somebody were to ask me, hey, John, the Quattrone Center published a report. Is this a lot of misconduct or a little? What I would say is, I don't know, because I have nothing to compare it to, right? So the fact that there's a number with data out there, until we start looking at trends or comparators, means very little to me. Maybe we're the least misconduct in the nation, right? But I guess and I know that you see data that way too, that you're not afraid of data. So maybe you could talk about why it is that we don't have systematic ways to gather this data, and whether that's something that's even feasible on Earth.
Yeah, I mean, first of all, thank you for allowing me to be a part of the panel. I think, for the context, here in Cook County, we're the second largest prosecutor's office in the country. We have, when we're fully staffed, about 800 lawyers. We do about 40,000 felony cases a year and upwards of 100,000 misdemeanor cases. And to the point that was just made, a small fraction of those cases go to trial. And so in as much as we believe in sharing and being proactive in sharing of our data, we don't have a mechanism to capture what prosecutorial misconduct looks like, even in the data that we have. When I first came into office in 2016, one of the first positions I created was a chief ethics officer. We'd never had a chief ethics officer in the state's attorney's office. And the reason I had done that is my experience as a line assistant many years ago when I was young and was preparing a motion to quash arrest and suppress evidence, and separated my two police officer witnesses, and one police officer gave a version of events. And I went and prepped the other witness, the other officer, who said something that was different than the original officer. And my face betrayed what I didn't sit stone faced. And the officer said to me, did I say something wrong? I said, continue on. And he said to me without hesitation, what do you need me to say? What do you need me to say? And I said, well, the truth, just tell the truth. And immediately I ran to a supervisor and said, what do I do with this? And my supervisor said to me, well, just don't call that witness. Just don't call that officer. And I didn't. And it bothered me for years of whatever happened to that officer and what another of my colleagues have done in that situation. If I'd have put on this witness and this witness had comported to what he thought I needed to say, that is obvious prosecutorial misconduct. But there was no mechanism whatsoever to be able to report it, to have the confidence to be able to do that, to do it when for so long it had appeared to me by the ease in which this officer had done that was an acceptable practice. So when you say, what is the actual number, I can tell you, the tip of the iceberg, visual that you had at the beginning of the slides, it's just that. And this was a case that was at, the motion stage. And how often does that happen? And so the problem that we have is being able to capture this real time. To your point, a lot of the information that we get around what we would deem misconduct comes after a published opinion has come back and we have to do something related to an appeal, and we see it and we have to address it, or in circumstances where the defense attorney may raise an issue, or the more even rare circumstance where a judge in real time may raise an issue on cases that have not yet gone to trial. And so it's incredibly difficult to quantify. I think, again, to your point earlier, because what is the definition? I think we can all, and most prosecutors' offices today are trying very hard to deal with issues related to Brady, because that is the most, obviously recognizable piece. But as you said, the spectrum continues beyond Brady to improper closings. And again, that's just on cases that go to trial. The struggle in a jurisdiction where we do so many pleas is to be able to capture that information in real time, to be able to address it. And we've not been able to do that in a way that I think it warrants, largely because we hadn't tried to do it before. And what are the mechanisms to get us there now?
So Miriam, you work with a lot of prosecutors around the country, and I know the Fair and Just Prosecution just released a brief on plea bargaining. I know that these are issues that you're looking at. I mean, is what Kim is reflecting sort of a common issue? I mean, how do other prosecutors around the country think about this? How should we be approaching this differently?
Yeah, so I absolutely think that the points that Kim made and John, that you and Ross have both made, are very much a commonality across the country. And perhaps what's not as common is we're not seeing offices going as far as Kim is going, and that, you know, really needs to inspire movement. I think the critical question that you posed at the outset of what are we talking about here? What is the it that we're trying to measure and that we're trying to avoid? And I think if we start with too narrow a framing of prosecutorial misconduct, we are absolutely going to miss the mark. And instead, if we perhaps approach it from the lens, not so much of the behavior of the prosecutor, but the impact of things that prosecutors do and the clout that they have that impacts individuals, look through the lens of people who are affected and injustices that occur and ways that we are influencing the lives of individuals who come into contact with the criminal legal system, we're starting in a better place. And so thinking more broadly about where are there areas where there are concerning prosecutorial practices that we should be trying to measure and to proactively, to measure, to remedy, and to proactively address and avoid. That really needs to be, I think, the lens. And so a couple of thoughts, if that's really the way that we think about these things. First of all, we have to have new metrics around what is success in a prosecutor's office and what is success for individuals within that office. Because for too long, we've been measuring success by convictions, by guilty pleas, by length of sentences, by volume of cases, by volume of indictments. If we use those quantity-driven metrics, we are not driving to a set of values that is looking at, are we doing justice? Are we keeping our communities healthier and safer? Are we giving individuals and survivors and victims of crime the sense that they are feeling hurt and treated with respect and treated with dignity? Are we making people whole through the course of our process? So we need to look at a whole different set of metrics. And Kim and others around the country have been involved with a project called the Prosecutorial Performance Indicators that is trying to reset that calibration and that really kind of moral compass around what are we trying to do here and what are the values that we should be embedding in metrics. I think we also need to recognize the invisibility problem that your report talked about, that Ross alluded to. I mean, we know that nationally, over 94% of state cases are going to be resolved through a guilty plea. And so if those things are going to fly below the radar, and if misconduct and what we're trying to address is defined by a court finding of something that's gone wrong, again, we are missing the mark because 94% of cases are never going to get there. And so we have to look at in what ways are offices being transparent about things like plea practices? What are they doing to build policies that are embedding within the office the notion that we should make a just plea and a fair plea? There shouldn't be a trial penalty. We should keep that open as long as, you know, is reasonably possible. We should not have plea practices that are coercive, that force people to give up their rights or to plead because they are in fear of a harsher consequence that they're being threatened with. So I think we need to look at those things that fly below the radar. I think we need to look at how do we make the invisible visible. And I hope we'll talk more about this later. I think we also need to look at early warning systems. What are we doing to create a system where the alarm bell can go off systemically and individually as to prosecutors that should concern us before the problem has festered and reached the level of actual court findings of a problem or misconduct?
Yeah, thanks. That's, I mean, a lot to dig on for sure there, Miriam. So Mark, let me turn to you and ask kind of, you know, to Miriam's point, like, are there internal tracking systems? Are there technologies we could bring to bear that would kind of change this environment and enable Kim and the other prosecutors that Miriam works with to have such an early warning system? Like what might that look like?
Okay. Hi. Let me start by saying that I am thankfully the former director of the doctoral training program. I finished my second 3-year term and I'm now on sabbatical speaking to you from my office as a visiting scholar at Vanderbilt Law School. So
somebody needs to update their website.
But I think that, I think all of the ingredients have been touched on in terms of, I think the bottom line is, I think, a shift in frame of reference, as Miriam suggested, away from only looking at egregious, unlawful prosecutorial misconduct to looking at rebalancing the power between the prosecution, defense, the courts. We know as a result of sentencing reform and mandatory minimums that power has shifted towards the prosecution. The jurors are out of the process, so they're no longer a backstop against government overreach. Courts are only minimally involved in the plea process. And in terms of the whole process itself, there's a real need for transparency. In terms of sort of internal, I think it all turns on, and I guess Kim is, I think, already participating in moving this forward. It's a need for a performance-based information management system. I think something that can track within the prosecutor's office and maybe also outside the prosecution office as well. So internally, things like have the prosecutors document the prosecution filing for every offer with the court, including information about what charges are being brought against a defendant, every offer made, pleas accepted, incentives offered in exchange. So documenting that kind of information, which provides some basis for judicial oversight, and also, I think, enhances the potential legitimacy of the process as it's perceived by of all of the various stakeholders. The other is a shift in incentives. Again, Miriam mentioned that it's a kind of now a adversarial zero-sum game, win-lose. And prosecutors, their goal is to win, and the defense, and a system that's really ending up in guilty pleas, their goal, which is, it's kind of like in baseball, even a lower average, but is getting an acquittal, an all-out acquittal. And here we're talking about a system. So I think that a change in incentives from conviction rates and exonerations to also looking at the extent to which the plea negotiation includes elements that promote things like recidivism reduction, cost containment. What are the mechanisms of getting there, whether it's diversion programs, treatments inside or outside prison settings, community-based alternatives, various alternatives that, as John suggested, we need some baselines on. And we have baselines in terms of the current functioning of the system. And so progressive prosecutors can start to move in this direction, by using these information management systems. And I think changing the incentives so that there are rewards, so that you're not just looking at your win-loss rate, but you're really looking at and getting rewarded for reducing recidivism. We know in juvenile justice, we have state-of-the-art interventions that can reduce recidivism from 70 to just above 20%. Well, what does that mean in terms of public safety? Every percentage reduction is a reduction in the number of crime victims and an increment in public safety promotion. What about costs? We know in New York, I was part of a panel when Governor Patterson was in place, and they looked at some of the deep end kids in juvenile justice. It costs up to $200,000 a year to keep them in an institutional setting, when we know that there are even more effective community-based near home alternatives that are much more likely to lead to recidivism reduction. And I think by incorporating these incentives, it's a means of changing the culture away from, a culture that's focused on win-loss. I think it also takes some of the pressure off of recognizing that prosecutors are embedded in a system that is designed for them to engage in behaviors that lead them towards winning, but don't necessarily present them in the best light, to the extent that they are using every means available to achieve what it is that the system is pushing them towards. And so it takes some of the pressure off of blaming the personal characteristics of prosecutors per se, and looking at the system from a more systemic perspective.
Yeah, and I mean, look, I think one of the Quattrone Center's kind of formative quotes is you can't change the human condition. You can change the condition in which humans make decisions, right? So people are going to make mistakes. Sometimes people may even kind of deliberately color outside the lines. And part of the name of the game, if we're going to improve quality, is to change the environment in which those decisions are being made. So which is, a lot of what I hear you saying there, Mark. So thanks for bringing that kind of cultural aspect into it. We have a question here, Ross. I'm gonna describe the question and then ask for your thoughts here. I'm a sucker for a good Tiger King reference, and so this is a question that points out that in Tiger King, the court refused to hold a hearing on prosecutorial misconduct, and so when you don't have that trial record, it's tougher to make it an appellate issue. You've got to go to a habeas context. And so the question that's asked is, how can we get more hearings on misconduct at the trial level to make it part of a direct appeal rather than a habeas proceedings? I want to take that direct question and maybe expand it a little bit. If, one of the things that I noticed in the data that you presented was how many of the cases did not address prosecutorial misconduct, even at the judicial level, right? So we had this group of cases where it was alleged, and in, I think, 25% or roughly of those cases, the courts didn't even address it. They resolved the case on other issues. In an environment where folks like Kim, are only hearing about misconduct from judicial opinions, what can we do to expand that? And is that a way to change the environment a little bit? And are there other structural ways to do that?
Sure. I mean, thank you for expanding the question, because I don't know that anyone knows the answer to that direct question. I mean, that's something that is just an inherent part of the system. But you've in your question, you sort of already alluded to, I think, some of what the answer is that because when these issues are raised, when misconduct claims are raised in the context of court, they then have to fit through the particular shapes of those holes, right, in order for them to be a claim, for it to be cognizable, for it to be something that does or doesn't warrant relief. And you even see in the big ones like Brady, for instance, a lot of people that don't do this stuff all the time might think that Brady implies some sort of intentional act by a prosecutor, which of course people know it doesn't. And then there's the big question of materiality, which is totally separate from whether or not the evidence was supposed to be disclosed. And so there are lots of sort of complicated nuances that exist that, one way to approach it from a policy and reform standpoint is to think about sort of making that make more sense and figure out what the objectives are. And of course, we have, in the recommendations, we think of things like open file discovery as one way to potentially avoid a lot of these issues, is that if you don't have to, the prosecutors aren't stuck in a position where they think they have to make a decision about turning something over. The fights can be about relevance, right, and admissibility. They don't have to be about whether or not defense lawyers get them. And I think, so that's one way I think to approach it, is to think about those, how information is exchanged, because one of the fundamental characteristics in that environment is prosecutors, by the effect of their special role, have a lot of control over a very unbalanced information exchange, right? Like the prosecutors have control over the information, and so they're in a unique position to make sure it goes where it's supposed to go. So I think that would be one suggestion. And what you mentioned in terms of looking at the cases, one thing that kind of came up as we talked about different ways to think about this. And it was interesting how, although this method has lots of caveats and limitations, it still is a data point. And we were trying to think, at one point, what other industries are there where you actually have this no cost environment where some other place is evaluating the output of your employees and then occasionally says, hey, this person did a bad job, and then it's ignored. It doesn't mean that they got it right, but there's information coming out from those sources that can be used just from a quality control standpoint for prosecutor offices to look at that, the information that's coming out. It doesn't necessarily have to be the big appeal that, has a major issue in it or has, more immediate consequences. It's something that can be leveraged to provide that quality control. So I think, the existing data from opinions can certainly be maximized because there's information in there that's a useful starting point. And I think looking at, those processes that, you know, the things that got us to the point of those events that are described as misconduct, those are probably the places we should be focusing on, is in trying to prevent it from happening. And as you said, change the environment so that, you know, well-intentioned prosecutors are not stuck with difficult choices, and instead try and create an environment where that information imbalance gets a little bit more even, and you don't have to make those individual decisions. So I think that rather than looking at how do we litigate this better later, I think most people would probably agree, if we got two buttons to push, I'll push the one that says, let's prevent it from happening, or at least limit it from happening in the first place.
John, can I jump in while you're still muted?
Great. That's the best
You were
time
about
to do
to
it,
say,
actually.
Kim, as soon as I come off mute. Just to piggyback off that for a second, you know, one of the things that we have, you know, my bio needs to be updated. We're now at 154 wrongful convictions that have been vacated since I've taken office. A significant chunk of those came as a result of, you know, a corrupt police officer shaking down people in this one public housing project. And a lot of attention has gone to, you know, oh, what did this police officer and this crew did? Look at this. They only made the arrest. We prosecuted those cases. And so as we were looking at the review of the cases, right, to make a determination as to whether or not, can you hear, I'm sorry, as to whether or not we would vacate the conviction, some of it was very easy to see that the reports weren't up to snuff. It was very easy for us in the review to say, this looks like a copy and pasted report that was given to us. What was the interrogation of the officers? As we look at it now, and it is no brainer to say this is a conviction that cannot stand, how do we take that information and to your point, train around it? Because there was a direct action by prosecutors who've been given information, and whether they shared the discovery, I will assume that they shared the discovery in a timely manner, but there were behaviors that were acceptable in the review of this information that allowed for, most of these cases were disposed of by plea. To get to that bigger picture of you're not going to see them, most of these cases were disposed of by plea. The defendants in these cases, many of them had previous drug or gun arrest, which is what made them susceptible to this crooked police officer, because who would believe them? And so when it is now time and we've got our evidence that, again, in hindsight, looks shaky at best, and we're leveraging that defendant's background, their attorney, to the point that was made earlier, is trying to mitigate what the potential harm could be. And so they plea it out. But we've been using these Watts cases, as we call them, as an opportunity around the ownership of the role of prosecutors in this, because it's not just a police scandal. We pled these with evidence that isn't sufficient. And how do we train on that, right? I'm assuming that falls in Ross's other category, because it is it, you know, lack of due diligence, lack of interrogation. This is a slam dunk. This person has a background. I'm just going to make an offer without being thoughtful about it. You've got the discovery. So a real area of opportunity for us to do a review based on what's already happened and try to put mechanisms in places to do some type of more real-time auditing of how cases are being disposed of, how offers are being made. And again, taking the learned successes, because we view, as awful as it is, these 154 exonerations we celebrate that we do the right thing, however long it took us to get there, as a prime example of how we can do better, train better, and put mechanisms in place. So just, you know, a thought that I had about how difficult this is in real time, but not absolving us of being able to say, once we get this information, how to do better.
You know, I just want one more point on that too, because Kim just raised something I think is really important, talking about the pleas and how, and kind of evaluating that evidence post hoc. And I think one of the compelling reasons to think about early, you know, equilibrium on information and open file discovery is that, you know, as we know from exonerations and conviction integrity units, the defense can actually be helpful to that process. And so, where you see a lot of these pleas and some unknown number of them are being driven by, the prosecutors may think, oh, we've got a problem with this witness, we have a problem with this evidence. I think we maybe want to make an offer that sort of is reflecting the fact that we have some concerns. The defense may have information that could actually shine a lot of light on that issue and perhaps could even make an even more compelling argument that maybe the case should be withdrawn or something else. But defense are in the position that they don't have to share anything with the prosecutor until such time as it's beneficial for them, which is one of the very few advantages they have in that setting. But I think that open file process, if a case is going to wind up on a plea or it's lower culpability or whatever it is, that may be a good and correct result. But if both sides have the same information, you'll have a much better chance of really finding out the true and fact pattern, because the defense may have information that what looks shaky to a prosecutor could be completely exonerating with additional information that's not being provided, because the defense attorney is always kind of waiting in case they have to go to trial.
And John, let me also jump in on some of those great points and just kind of reflect back on the extent to which the question that was focused on what are court solutions and how do we drive court processes that can better identify and remedy these problems, again, presumes that should be the singular pathway to both problem identification and problem solution. And clearly we know that, as we talked earlier about that funnel, what gets to the court is just the tip of the iceberg. But also, even when things do get to the court, the fact that the court might find that there's no basis for a remedy, or might conclude that there's no basis for concluding that something meets the very narrow legal definition of misconduct, does not mean that there is no problem, and does not mean that there can be no solution. And so if we accept that starting point, that the courts should not be the only pathway or even the best pathway to addressing these issues, and a court finding that there's nothing there does not mean there's nothing there, then I think when we are willing to look to other industries, as was referenced earlier, there actually are some great teachings from policing. And again, there's a lot policing needs to do better, but there's also a lot that we can learn from policing. And when we look to policing and even other industries, we know when something goes wrong in policing. There is an after action review. There is a critical incident review. There is often, and John, you've been so wonderfully involved in this, often a sentinel event review. And all of those are focused on what can we learn? What did the system mess up on? Same thing happens in the medical profession. There is death review. What can we learn from where the system went wrong? And not just what the individual did wrong, but all the many things that enabled them to get to that point. What did we do wrong in hiring? What did we do wrong in training? What did we do wrong in supervision? What did we do wrong in terms of policies within the office? And so I do think learning more how we can make those sorts of exonerations that Kim talked about be teachable moments. And her office is doing that. The Brooklyn DA's office is doing that with conviction integrity review reports, where they are putting out there for the world to see not just what happened in this case, but what can we learn from it, just as we need to be thinking about things like audit and inspections in prosecutors' offices, ways to assess integrity to policies, ways to proactively create policies, as well as a culture that's going to avoid these problems in the first instance, early warning systems that are going to trap patterns where remedies are needed, and thinking about external oversight. And I know that can make people uncomfortable, but our community has a role to play here, just as if there are pattern and practices of things that have gone wrong in a prosecutor's office, there could be a role to play for outside entities. So I think all of those things need to be on the table as we think about how do we do better and how do we ensure that individuals truly get the justice that they deserve.
Yeah, thanks. I think in the first place, thanks for the plug on sentinel event reviews, because obviously that is work that we do. And we find, particularly in these wrongful conviction cases, I think kind of to the point that you made, Kim, about, yeah, the police brought bad cases, but we prosecuted bad cases, right? What we find in these wrongful conviction cases is inevitably you start with an inaccurate arrest. And I use that word inaccurate, carefully, because I'm not suggesting that anybody knew that it was an inaccurate arrest. Maybe they did, maybe they didn't. All we know is if you're going to have an exoneration, it starts with the arrest of a person who didn't do it. But then all of the other parts of the system and all of those checks and balances, the prosecutorial screen for, is this something we can move forward? The prosecution of it, the defense, the judge, the jury, all of those are checks and balances designed to reveal inaccuracies, and all of them failed. And so when we bring all those people together for learnings, it really kind of democratizes the opportunity for learning, because you can really elevate every part of the system. One of the reforms that we talk about in the report is to something that's actually in the new model code for the ABA 3.8. I don't remember if it's G or H, but it says basically that judges will report information about misconduct to the disciplinary board, and the disciplinary board will conduct an investigation. And it takes some of the discretion out of that as a way not to necessarily change who gets punished, but a way to make sure that we are looking at these things and kind of creating that. One of the questions that came in is a question about prosecutors in New York being now required to turn over and share all materials with the defendant in a timely manner. New York's got a couple of reforms that I think are interesting in this context, and I'd be interested in anybody in the group's kind of reactions to them. One of them is the idea of standing orders in a court, where you're certifying to a judge that you have done your Brady obligations, right? Pause to note that in our data, we had two different types of Brady. One was where the prosecutor had failed to turn it over. Another was where the police officer had failed to give it to the prosecutor, which is, I would describe as the prosecutor's burden, but not always the prosecutor's fault. And the second thing that New York tried to do is to create, Miriam, to your point, an external advisory board. And that then ran into challenges with the State District's Attorney Association over whether or not it was constitutional, and the DA's Association saying, thank you very much, but we're not sure we really want an advisory board. So let me that's a bunch of reforms that I've thrown out there. And let me just sort of see, now that I've trolled the pond, who's going to take the bait?
I was gonna let Miriam take the bait. I read the question in the chat, and you went a little further. Listen, I think I'll start with, here in Cook County, just to specifically answer the question. We have a policy in our office that you are not to tender offers on cases without full discovery having been turned over. Because it just doesn't seem how a defendant can make a fair assessment of their odds at trial if they don't have the discovery that has been tendered. And so that's something that we have done. Largely to eliminate, the point that was made earlier. We might have a shaky case. I don't want you to know how shaky it is. I'm going to give you an offer. That's also not justice. And so offers should not be tendered unless discovery has been fully complete, unless the defendant comes to you and says, I know I don't have all the discovery and I want an offer anyway. That's a different scenario. But the way that we approach discovery here is that it has to be done before we get to that point. So as not to have everyone at a disadvantage. In terms of oversight, and again, I'll talk very fast on the Miriam Co. Listen, it doesn't surprise me that the DA's Association is loath to some level of oversight. I imagine if you did that here in Illinois, the same thing would happen here from many members of our association. I think the problem has become, particularly when we're talking about accountability in the legal system, is the point that was made earlier. There's a tremendous amount of power in the prosecutor's office and very little transparency in how we do our work. Very little. And, for whatever we've been able to do, putting felony case level data on an open data portal, that's still not telling the story. It's still not telling the stories about how we do the pleas. It's still not telling the stories about, those incentive structures that Miriam has talked about. One of the things that when we were prepping for this, I told you about a supervisor in our office many years ago who went up for a judicial appointment, and the bar associations had done a review and found that there were at least a dozen instances where an appellate court found that she had engaged in improper closing arguments. And this was like a dozen. So you're like your very small sample, which is why I'm like, I'm absolutely certain your number is cute, but not accurate. Is because I knew one lawyer who had a dozen, and she was heralded in this office as being, hard charging, tough. The fact that she used rhetoric or language to define a defendant, that was celebrated as opposed to appreciating that it was misconduct. And this was someone who, despite the Bar Association saying they were not qualified to be a judge, continued to sit in a leadership position within this office because the understanding of like, how do we define this? That was part of the culture. And the knock, the fact that we were coming back to address it again seemed minor in the larger picture of who we were as an office. And so I think that's my long-winded way of saying having outside oversight to look into cultures that have fundamentally had a problem policing themselves in order for us to have best practices and best outcomes is essential, is absolutely essential. And I think we are one of the last bodies to have this much power to not have that level of oversight. And I think it's long overdue.
John, if I could just add in, I think that, it's understandable why they would oppose it. You would expect that they would oppose the outside oversight.
I don't want more oversight myself, so I can kind of understand that too. I mean, let's be clear, right?
And just to say that it has an adjudicatory, punitive element to it. And I'm wondering whether or not moving something to, say, the state court administrator's office, where you would be collecting information and you could use that information to implement policies and bring about policy change, and not being seen so much as adjudicatory, but as a means of tracking, gathering information, and trying to push towards positive goals. It might be more easily accepted and might also be a means of pushing the culture in a different direction.
Yeah, and look, I mean, I think one of the things that we have found is that there were definitely some folks when we released the report who said, you guys are saying that the prosecutorial misconduct is rampant. And we actually said, well, no, we're not actually saying that. Maybe it is, maybe it isn't. But part of the problem is, to Kim's point, the transparency isn't there. And in today's environment, there's a cynicism about law enforcement that leads people to then assume the worst. So part of what I think we do is with reports like this, we're hoping to start a conversation that kind of demonizes the use of data, right? We want to use the data to get better and say that the statement that we have room to grow doesn't mean we're terrible, right? It means we have an obligation to get better. So Miriam, I think I might have interrupted you as you were going to say something now.
No. I mean, I think your point was so valuable, as were the others, John. I mean, I think the easy part of the question you asked is, does there need to be open discovery? Should there be discovery and, full access to discovery before somebody decides on what decision they need to make about a plea disposition and what will impact their lives? Absolutely. And we shouldn't fear that. I mean, I think as Kim said, we should welcome that. Prosecutors and defense attorneys alike should be on the same page on that, because there could be holes in the case, there could be problems in the case. And if everyone agrees that the aim here is not a quote unquote win, not counting convictions, but rather a just result, then we should be aligned in the search for a just result. I think on the commission issue, so actually, I was on a panel at Columbia Law School when that proposal was going through, being batted around in New York. And not surprisingly, I was on the side, and there were others on the other side of it, of very much welcoming that type of a vehicle. I think that, as was recognized in your comments and in Kim's comments, if we don't have a system that people can trust, then all of us are going to lose. Prosecutors, law enforcement, the community, and everyone who makes their way through the hallways of criminal courts. We all lose if the system can't be trusted. And ensuring that the community is part of building that trust and external oversight, I think, enables that seat at the table to be created, is part of rebuilding trust at a time when trust is low. And I also think, and I saw this during 5 years working on law enforcement reform, at times, the acts of a few cast shadow over an entire institution and destroy trust in that entire institution. And I know Kim has seen that, in the context of policing and other instances. I saw that very much so in policing. And I saw a lot of law enforcement leaders who feared external review become big fans of it, because what they saw is the ability of external review to create a partner, to create a vehicle for identifying where systemic change is needed, to set a table where conversations and engagement of the community can happen. And so I think that we really need to get beyond the fear of these kinds of bodies. I mean, obviously the devil is in the details in terms of what it includes, what it can do. And the final thing I would add to this is, not only are the courts a very inadequate vehicle and far too limited vehicle for dealing with these issues, but I also really fear our presuming that the state bar is going to solve any of this. And yes, there should be more reporting, and yes, people should be encouraged to report. I chaired in California our state bar disciplinary committee for a few years. And what I saw was a microcosm of a report that Innocence Project and Veritas had put out a couple of years ago that I think, John, was one of the reports you alluded to, where they looked at 5 states over 5 years, 660 cases of court findings of misconduct. Only one prosecutor was disciplined. What I saw was not simply a failure to discipline. I mean, when I was chairing that committee, we were very much welcoming opportunities to show that the state bar was a partner in this. Nobody was reporting cases. So you can't discipline what doesn't get reported. And I think we can try to encourage more reporting. But again, I think we're fooling ourselves if we believe that state bars or courts are the solution here. We have to look earlier in the pipeline, and oversight bodies, prosecutors who share the starting point that Kim does, that's how we're going to scroll earlier into the process, in my mind.
So let me ask you all this question, given, the different players in the system other than courts, right? So there is a question here that asks about states like Mississippi that don't have investment in public defense. So, one question is how might this be different in those states? But another question, given that we're kind of presenting here to an audience of reporters, is, you all are either Kim, you're the recipient of a lot of that media, people, writing about your office and all that. So, like, how can we help reporters report on these things more constructively? How can the media help to shine a light on this in a way that is, productive in actually improving the system?
It's a great question. I think in the same way that I talked about the example of the Watts cases or the exonerations that we've done, to ask the questions about how we got there. A lot of times we do these and there's a press hit and people want to talk to the individual who had their case exonerated. How do you feel? What was the impact on you? And not the, how did we get here? And I think kind of that deeper examination of these patterns and trends that we've been able to assess and develop, a real interrogation of the system. And I think that is really helpful. I think for so many people who don't understand how the criminal justice system works, who may see a trial on television and believe, we've seen a lot of high profile trials on television just in the last several weeks, related to, whether it's George Floyd's officers or Ahmaud Arbery, and one would believe that most cases end in a trial. And that is really an anomaly to see those cases go. And so I think from a journalistic perspective, I think it's incredibly helpful to delve into the processes. It's the least sexy part, the human interest part of these stories, the tear jerkers or get you like your heart tugged, but it is the mechanics. Because if we're just at 154 cases, and I don't mean to sound trivial, my fear, my heartache is that there are far too many more, so many more. I saw the question in the questions about, conviction integrity unit. There isn't any standardization. We inherited what we had. We've tried to tweak and do more. These cases take a really long time for us to review. Many of them are years to upwards of a decade old, and we're doing the best that we can. I think the light being shown from a journalistic perspective of how prevalent this may in fact be allows for the legislative push for some of the things that have been recommended, right? There are things that we can do in our offices, and I know my colleagues across the country are very committed and thoughtful of this, but there are some legislative mechanisms that we need, and the way that we move legislators is by shining the light. And the biggest bully pulpit that we often have is local media. And so I would say get beyond the original headline of some of these cases and get into how do we find ourselves here? What are the common threads that we can see in these cases and interrogate that? That it would be incredibly helpful for me. I have found that a lot of the coverage of our office, rightly or wrongly, is, around the sensational. And what about this work, it's the mundane that is actually the most insidious and dangerous to our justice system. And I really wish people would pay attention to the mundane.
So there's go ahead, Mark.
The broader theme is whether or not the momentum for progress has stalled. And I think I would just take example, the bail reforms and the media attention that's been on all of the cases where things have gone wrong. And I think one way for the media to focus is also to get out there and talk to people where things have gone right. Someone who would have otherwise sat in Rikers Island, who's now out on, has not been subjected to bail, who's now able to continue to work, help in their defense, parent their children. And so getting out those stories about saying, otherwise I couldn't afford bail, and I would be sitting in Rikers, and here I am. So get those human interest stories. On the other end, on plea bargaining, maybe it's investigative reporting, talking to people who have been through, who have negotiated pleas with prosecutors and ask them exactly what that process was like. And maybe you want to de-identify it, so you're not identifying the people who are outing the process, but getting behind the scenes and talking to the people who are actually going through those pleas and talking to them about exactly what their interactions were like, both with the prosecution and with their own defense attorneys.
So, one of the questions that I wonder about when we look at the prosecutorial landscape and information sharing, right, is how can we, to the point about we should be providing all this information prior to a plea, which I know FJP has advocated, and Kim, you advocated for this, and Ross, and when you've been in your defense role, trying to figure out that balance. What if we had like a place where you could just have infinite data storage? And I'm going to, what if, I'm just going to call it the cloud, right? And what if there was something that could do immediate role-based access, and we could call it something like Dropbox, right? Like, what would happen if we just scanned everything and put it into this magical place called Dropbox, and then anybody who had passwords could access it right there in real time, right? Like, why are we not using the technologies that we have to change the environment today? Because I feel like that's actually kind of a municipal question and not a technology question as things are unfolding. And Miriam, I wonder, if you have an experience with that, or if your prosecutors as a group, right, not wanting to out anybody, but if that's something that's up for discussion with your group and something that could be helpful here.
Yeah, I mean, I completely agree that we need more out there. And as your question, posited, I mean, we have the tools, we have the ability to put a lot of information out there. Kim's office is putting a lot of data out there. Other offices have been launching data dashboards. They've been putting, different kinds of after action assessments out there. I think there's a lot more. And I think that that we need to be doing it. And I think it kind of links to the prior question as well. If things were more accessible, I think the mundane could become easier to drill into, and there could be a better ability for reporters, as well as members of the public, as well as community groups, to do more to understand what do we know and what can we take away from what we know. And I also think that we should applaud the fact that this is happening and communities are better understanding the role of prosecutors. I mean, we see that now in the election process, in far more voters going down ballot to even exercise choice around prosecutors. We're seeing more contested races where incumbents are being challenged to have a conversation about, what they do and why they did it. We're seeing community groups more engaged in understanding what their prosecutors are doing on a host of issues, this one among them. So I do think we're finding that there's a deeper understanding of the tremendous clout that prosecutors' offices have, that people are asking more, demanding more, wanting more information. But clearly, there's more work to be done. And one area I'd throw in, just in case this question didn't have a chance to ante up, is I think one of the other areas where there's more work to be done, especially in something that I believe is a good thing, is responsive to the community through a process of election. I mean, I believe that is a big positive, that elected prosecutors, Kim and others, have to respond to the community, and that the community has the opportunity to elect change agents like Kim. And that is important. I think we otherwise may not see change but for those processes. But I do think that it's important that there be distance between prosecutors and law enforcement, and that elected prosecutors make that distance clear, that law enforcement is a partner, but they are also a separate stakeholder, and that prosecutors have a role to oversee and hold them accountable, meaning they shouldn't be taking contributions from law enforcement leaders. They should not be receiving endorsements from leaders in law enforcement. We need to kind of disentangle those sorts of relationships so that prosecutors can adequately fulfill their role of being independent overseers of one of the biggest partners that they have in the criminal justice system, that needs that separate accountability to come from elected prosecutors.
Yeah, thanks, Miriam. And I think that's actually responsive to one of the questions here about, how do we find incentives for prosecutors to call out bad officers or bad prosecutors if they're taking those endorsements and it goes against, their personal or professional interests, right? So I think the answer to that is, well, let's remove that incentive, and then we are more immune to the criticism that we're linked in that way that is unproductive. Ross, let me kind of ask you this question. As you looked at the data and were preparing the report, I gave a couple of takeaways at the beginning of this. What was the thing that surprised you the most about the data that we gathered, or about the data that we weren't able to gather? What do you think that the reporters that are here should be pushing for as far as getting more data from their prosecutors?
Yeah, I mean, it's, many of the things in the report were not surprising, right? There were things that we sort of suspected and we had other indications for. I think one of the things that was surprising to me was to see, how many of these cases where, and as we're going through and coding these cases, Miriam, I think, made this point earlier about the sort of narrow requirements, to make a prosecutorial misconduct claim. It was a little bit surprising to see how many cases described conduct that was just kind of patently problematic and that was repeated over time in a particular office. And then to see that not result in any kind of legal process. So it's like, it's even narrower than we maybe would have expected. And then also we went to look to say, well, maybe at least this is triggering some kind of review at the level of the prosecutor's offices, and found that there was no indication that was happening either. And, Miriam talked about the sort of non-role of disciplinary boards, and we had similar findings in Pennsylvania, where there was over 3,000 disciplinary cases over that time period, and only 2 involved prosecutors. And in one of those cases was a prosecutor that had multiple findings of pretty serious misconduct, and courts sort of saying, hey, this is, a massive problem. And then but that same prosecutor stayed in the office for years, kept getting cases, and then ended up with 5 that got listed by the disciplinary board. But it took about 8 years from the first one until until that attorney was actually sanctioned and ultimately disbarred. And so I think that's one of the things that I think from a journalism standpoint, that's where the system actors kind of don't have those tools to try and understand that. But that's something that, when those things happen and there are these indications, what's happening at the level of these offices, what's happening in terms of, just from a fundamental quality control standpoint, what's happening there. And I think that seeing that kind of repeated conduct, and then, the other thing that, again, talking about the limitations, that's the flip side of that coin. Judges rarely named prosecutors in the opinions, or named the offices, even though it's easy enough to figure that out. But what we saw in the tranche of unpublished cases, which are not easily obtainable, judges were a lot more free with their language, and in those opinions would often say, this is horrible, it's the worst thing, this person shouldn't even be a prosecutor, how dare you? And then that opinion's not published and serves absolutely no purpose for anyone else other than the local office. And in the few examples where we found some of the most extreme language, the prosecutors that were specifically named and called out, albeit in the unpublished opinions, still continued to operate in the offices and didn't receive any sanction. So that, again, just kind of the level to which the judicial system is clearly not a massive part of the solution to the issues that we're describing.
Yeah, and I actually I'm struck by how that might play out in actually the current conversations about our Supreme Court nominee, right? About having a defense attorney, and about some of the more kind of unbelievable to me topics about, whether the narrowing of that nominee was in some way a reduction of quality of that nominee. Kim, I often thought of you and as I was reading that stuff and just kind of shaking my head. But I'm digressing now and probably shouldn't go into these areas. So we've got about 9 minutes left. And I guess, Mark, one question that I might have for you is whether there are things that you've seen in your work with juvenile justice, which, juvenile justice is kind of a particularly information cloistered area, and for valid reasons, right? Whether there are tools for quality control that you've seen in juvenile justice initiatives that we might be able to port over to this area. Because if you're able to do those in an area where you've got all these extra privacy protections, maybe that would be something that we could bring over here that would be useful. You're muted, Mark.
I basically, I think, start from a premise that's similar to what Miriam was suggesting before, is that maybe the judicial system, the trial system itself, is not the best vehicle for attaining accurate and fair results. And so what I've been spending mainly is to say, given the juvenile justice system does have some more flexibility, and some of the things that we consider to be sort of important rights inherent in our legal system, in fact, may not be consistent with a kind of system that does promote accurate and fair results. And so basically trying to then adapt procedures more from an administrative law perspective, not so much aimed at blaming, all of the things that we do in terms of everything we know from psychology that tends to fuel anger, resentment, aggression, conflict. Those are the kind of things that are at the heart of an adjudicatory, blame-oriented system that's looking to fix blame, as opposed to trying to understand why people do what they do and what can be done to bring about positive constructive changes. And so it's borrowing, partly it's kind of, reframing it within the flexibility of the juvenile justice system. But I do think it's also within and that's partly why the plea bargaining system itself has potential if the system is willing to open up and go beyond sort of a compromise in the shadow of a trial model, and to be the kind of system where you don't have the same kind of structural constraints built in, and so that you can define what your goals are and broaden the focus beyond blame to understanding all of the various participants in the process, and try to, I argue for trying to minimize costs, promote public safety, doing it in a narrow way so that you're not sitting there saying that we want to just give people treatment that's going to instantiate middle-class values, but that's going to say that society has a right to expect that people will conform to the rules and laws that we have, and that our interventions will be narrowly tailored to ensure that we understand why you're doing that and prevent it from happening in the future. So I've been spending more time just trying to reimagine, re-envision, and then using some of those principles to think about how we might rethink criminal justice and plea bargaining as part of that in a way that I think ultimately is part of the recipe for decarceration and dealing with our issues of mass incarceration.
Steve, I see you've popped back onto video. Do you have a question you want to inject with moderator's privilege here? Muted. We can't hear you, Steve.
You're muted, Steve.
I wasn't even thinking about talking, but I think that I just want to go back maybe to the question about whether journalists can, the limitations of what journalists can report on trials is always a problem in terms of the access they have to information. So I wonder whether the speakers have any sort of final closing thoughts on where they see journalists doing a good job and where they're doing a bad job when it comes to prosecutorial misconduct. Certainly, the idea of a conviction integrity unit has changed the approach that the media makes now towards police and law enforcement. There's no conviction integrity unit that operates for prosecutors, but I'm just wondering if there is a way that journalists themselves can accelerate the process and do a better job in reporting this. That's a blanket closing question.
Well, I think just from my perspective, and sorry, Miriam, I didn't mean to jump in ahead of you. I mean, I think one of the things is the sort of asking why, right, as the question that was made earlier. But I think to tie together points that a couple of other folks have made, one of the things that I think happens is because prosecutors have the power, so much power and so little transparency, when something goes wrong, we impute a bad motive automatically. And I think one of the things that the different categories of misconduct that we show in the report see is that it's possible. So many of these are happening in open court that it suggests to me that people aren't hiding the behavior, so they must not think it's bad. So that's one area of things. Within Brady, we invariably have structural reasons why things weren't turned over, good faith reasons why things weren't turned over, and bad faith reasons why things weren't turned over. And I think if the reporters can dig enough to be thoughtful and differentiate from mistakes, well-intended good faith error and misconduct, that would be a big service instead of giving in to the immediate desire to just ascribe bad faith to everything. Miriam, I cut you off as I've now done repeatedly here, so my apologies. Go ahead.
No, it's always great because you cover the most important stuff. I guess a couple thoughts. I mean, the first is any case, any singular tragedy is a doorway into deeper problems. And that's where kind of Kim's point around the more mundane, I would maybe even think about it as, what are the takeaways and what are systems doing, whether in that jurisdiction or elsewhere, to walk through the doorway and see where the pathway leads. And I think secondly, how do we get ahead of those tragedies and report the positives And, you know, too often reporting has been about the tragic case. I mean, we have a whole host of ideas on reforms that we are seeing happening around the country, and happy to talk to any journalist about how do we report the positive? How do we report where progress is getting made, not simply where we're falling flat? Because if we're not lifting up those pockets of progress, we're just going to wait for things to fall flat, and then we're going to continue to report the failure.
I think one of the problems here, just getting back to our central theme about the shelf life of reforms at this time, is that we've got ourselves into a situation where the idea of a progressive prosecutor or a reform prosecutor has suddenly taken on a bad odor in certain parts of the country. So when you see elections starting to happen where people just condemn someone as a progressive prosecutor and therefore they're someone who's soft on crime, or that they're responsible for, you know, the carnage that we're going through, there's no carnage. It's become an issue, just the language itself has become an issue that has gotten in the way of really clear thinking about what prosecutors do and what they can do. You don't have to be a progressive prosecutor or a quote reform prosecutor to do a good job and to really think about doing justice in your office. And I think that's an issue that we need to back off a little bit and instead of talking about labels and talk about what the function and the jobs are. And I'm sure that State's Attorney Foxx will agree with that, because she's been certainly at the hard end of a lot of the criticism.
Yeah, I've seen my name in a few articles. I think you're right. I mean, I had an editor of the editorial page of one of our major newspapers here tell me, when I was walking her through the data, they'd written something that was just woefully inaccurate. And she said to me, without like any sense of irony, she said, State's Attorney Foxx, you don't have a data problem, you have a perception problem. And that coming from the editor of the editorial page of the Chicago Tribune. And I think it is, you know, the expectation that I have from journalism is just that, right? The labels are easy, and so the narratives become easy. It's the confirmation bias. And to Miriam's point, you know, there's a lot of good work that has been done across prosecutors' offices that we just don't talk about. Or when we see rising crime rates that are happening in places where, you know, you have tough on crime prosecutors rising at the same rates that you have, you know, quote unquote, progressive prosecutors. And so I think this tendency that I have found, and it's no knock on journalism as a whole, of we've identified the good guys and the bad guys. And in the conversation right now around rising crime rates, progressive prosecutors are being now labeled as bad guys. And the conversations around policing, like all police are bad. Like the nuance that is required to have these conversations, the implications of bad policy are generational defining and has real impact. I think the institution that has the greatest power, more than me as an elected figure, is journalism. And so the resistance of the urge to do the simple narrative and say, this is going to be longer than a soundbite. This might be a podcast. It might require a lot more words than we have available, but it's necessary. Because I think what scares me most about this moment in time, I often say, if I could go back in time to 1989, 1990, for prosecutors and legislators who were dealing with terrible violence in America, and see the policies that they enacted that in no way made us safer and in fact caused multi-generational harm. What was our journalism doing? What were the reporters asking? What were the stories being told? Because we're right back there again. And I think for those of us who are trying to hold the line on history, it requires a strong fourth estate to do their job.
I can't think of a more prescient note to end on. And we have to leave it there because we're just about out of time. But I want to thank all of you for a wonderful panel. If you were in person, I'm sure you'd get a huge round of applause. And John, thank you very much for a great job as moderator. So we will take a short break, 5 minutes, maybe 10, to collect ourselves before we go into our last session of the day, which naturally, in a natural form of progression, is about judges. So I hope you'll be able to stay. Thank you very much. Thanks all.